Hi guys, this is CA Balakrishna. In this video, we will be discussing case study number 15. Let us start with MCQs. MCQ number 1. For initiation of corporate insolvency resolution process against BSPL, basically BSPL is a corporate debtor, whether IPPL can file an application to NCLT jointly with, see, if you see, IPPL is a operational creditor. It has supplied some goods to BSPL. Now to this BSPL, there is a particular financial creditor by name UCL, and the operational creditor, only operational creditor, is IPPL. Now he is asking you whether this IPPL can initiate corporate insolvency resolution application against BSPL along with UCL, or application has to be filed only by the IPPL. If you see, financial creditor either himself or jointly with other financial creditors can initiate CIRP, or operational creditor either himself or jointly with other operational creditors can initiate CIRP. But operational creditor and financial creditor jointly cannot initiate CIRP, okay, cannot file application to NCLT jointly. Thereby, only operational creditor IPPL has to file the application on itself, okay, by itself, not jointly with the financial creditor. If at all there are any other operational creditors in the BSPL, then IPPL can initiate application jointly with other operational creditors, okay. Therefore the answer would be option D. IPPL can file application solely, only, and not jointly. Hope that is clear. If at all in the BSPL there are other operational creditors, then it can initiate jointly with other operational creditors. Next, the committee of creditors of BSPL would comprise of, see, we have already know that the committee of creditors would comprise only financial creditors but not operational creditors. In this case, financial creditor is UCL and IPPL is a operational creditor. Thereby here the committee of creditors will consist only UCL being the financial creditor. Option D would be correct answer. Next, assume that there are no legal proceedings going on between IPPL and BSPL, and NCLT admitted the application filed by IPPL for initiation of corporate insolvency resolution process against BSPL, but immediately thereafter IPPL and BSPL came to satisfactory settlement. In such case, application for CIRP. See, once the application for CIRP has been admitted, it can be withdrawn subject to the condition that at least 90% of committee of creditors provide their approval. So let us see the answer. He says option A may be allowed to withdrawn by NCLT on application by IPPL. No, it is not clear. May be allowed to withdraw by NCLT on application by IPPL subject to approval of committee of creditors with 90% voting share. Option B would be the correct answer. Next, whether the all-in cost of the debentures is within the prescribed limit under the FEMA. See, under FEMA, the all-in cost prescribed for external commercial borrowings is 7.5%, whereas in the case study he says that the debentures in the form of ECB is raised at an all-in cost of 6%. Thereby this 6% is within the limit of 7.5%, which is allowed. Answer would be A, yes, because all-in cost is 6%, whereas the prescribed limit is 7.5%. Next, which of the following statement is correct? Let us see. Rising of ECB through foreign branch of SBI is not valid because foreign branch of Indian bank cannot subscribe to foreign currency denominated bonds. No, the case study doesn't speaks about foreign currency denominated bonds, so that is not correct. Next, rising of ECB through foreign branch of SBI is not valid because the foreign branch of Indian bank cannot subscribe to debentures, funds of which are to be used for working capital purpose. This would be correct answer. See, if you read the guidelines of external commercial borrowings cannot be raised from foreign branch of a Indian bank. Okay, thereby in the case study, the foreign branch of SBI bank subscribes to 10% of the debentures that has been issued by the BSPL. Okay, which is not valid since SBI being an Indian bank, the foreign branch of Indian bank cannot, subscribe or cannot issue external commercial borrowings. Next, therefore C would be correct answer, only 2. Next, descriptive questions. Whether the application to NCLT for CIRP against BPSL filed by UCL is valid considering the fact that arbitration proceedings are pending as well as the loan was taken from the former company UFL and not UCL. Assume no application to NCLT by IPPL has been filed. Basically what happens in the case study is against BSPL, see, against BSPL IPPL initiates application to NCLT. Now in the question he is asking to assume that IPPL has not initiated any application for insolvency with NCLT. Okay, only UCL has initiated the application. Okay, assume this. That means UCL is a financial creditor and financial creditor has initiated the application for insolvency against BSPL with NCLT. Okay, now if you see, BSPL has taken loan from UFL and this UFL merged with UCL. Okay, now there is no UFL. UFL is merged with UCL. Okay, after merger with UCL, the loan amount that has been taken by BSPL will be transferred to UCL. Thereby UCL can initiate insolvency proceedings against BSPL. Okay, even though UCL has originally not granted the loan, since it has taken over UFL which has granted loan to BSPL, now UCL can initiate insolvency application against BSPL. Okay, that is one of the issue. See what he is asking, whether application to NCLT for CIRP against BSPL filed by UCL is valid. Yes, it is valid. Considering what? Considering the fact that arbitration proceedings are pending. See, in the agreement between BSPL and UFL, they have agreed that any disputes will be referred to arbitration. Now, even though arbitration proceedings are going on, the party can approach NCLT asking to initiate insolvency proceedings against corporate debtor, which would be completely valid. And also, once the application is approved by NCLT and under section 14, if moratorium is implemented, all the proceedings that are pending with other parties will suspend for certain period. Thereby once moratorium period is introduced, the arbitration proceedings will be suspended temporarily. Okay, Thereby the answer that has to be written down by you is that even though arbitration proceedings are going on, the party, that is the financial creditor, can approach NCLT asking to initiate insolvency resolution against the corporate debtor, which would be completely valid. And also, even though UCL has not originally granted the loan, since it has taken over a company which has granted the loan, now UCL can initiate CIRP proceedings against BCL. Okay, that has to be the explanation to be given for question number 6. Moving to question number 7. Whether the application filed by IPPL to NCLT for initiation of corporate insolvency resolution process against BSPL is eligible to be admitted or liable to be rejection. See, I have already told you that in the case study against BSPL, IPPL has already initiated the application. Okay, IPPL initiated the insolvency application. Now, before, if a operational creditor has to initiate insolvency application, it has to first of all give demand notice to corporate debtor. Okay, and a time of 10 days has to be given. When the demand notice was given, the corporate debtor, that is BSPL, has informed that it has a dispute against the material supplied by IPPL. Okay, against this dispute, BSPL has also filed a case with the court, okay, regarding this dispute. The same has been informed to IPPL by BSPL. Now, since there is a dispute regarding the material supplied by IPPL, even though IPPL files with NCLT an application for initiating insolvency, NCLT will not accept the application, since there is a dispute that is going on against the quality of material that has been supplied. Thereby NCLT will reject the application. That has to be the explanation given for question number 7. Next, whether BSPL allowed rising external commercial borrowings through an automatic route. Basically, in the case study, BSPL has raised external commercial borrowings of $80 million, okay, by issuing debentures which are completely foreign currency denominated debentures. Now, whether it is valid to rise through automatic route or it has to go through approval route, let us see. First of all, for rising external commercial borrowings through automatic route, the amount of external commercial borrowings should not exceed 750 million. In our present case, it is 80 million only. Okay, 80 million, which is less than 750 million. Therefore, it is valid. First condition is satisfied. Next, see, if the ECB raised by the any particular entity has been subscribed by foreign equity holder, okay, in that case ECB liability to equity ratio should not be more than 7:1. In this case, BSPL has issued debentures. Now, these debentures were subscribed by BSPUL to the extent of 60%. Okay, 60% of these debentures were subscribed by BSPUL. Now, this BSPUL is holding 56% equity shares in BSPL. Thereby, foreign equity holder has subscribed to the ECB's issued. In this case, the ECB liability to equity ratio should not be more than 7:1. let us see whether this condition is satisfied or not. See, amount of ECB riser is $80 million by BSPL. Okay, now BSPML is 56% equity holder in BSPL. Okay, such 56% turns to be total equity shares or 7 lakh equity shares, and face value of each equity share is 6 rupees. Thereby $4.2 million is the equity shareholding of BSPML in BSPL. Okay, you should also include the free reserves, share of the free reserves. Now total free reserves is 5 million. Of this 5 million, share of BSPML is 56%, that would be 2.8 million. Now total equity holding of BSPML in BSPL is 7 million. Okay, we have arrived at equity. Now we have to arrive at ECB liability, share of ECB liability. ECB subscribed is 48 million. How it is arrived? Total ECB issued is 80 million. Of this 80 million, 60% is subscribed by BSPML, which would be 48 million. Now you have to calculate the ratio, that is ECB liability to equity ratio. It would be $48 million divided by $7 million. This 48 million is ECB, this 7 million is equity share of this BSPML in BSPL, which would be 6.8:1, which is less than 7:1. Thereby, since both the conditions are satisfied, it can raise the ECB through automatic route. Hope this is clear. If you want, you can take a screenshot of this calculation as well. Okay, by this we have completed case study number 15.